SJC-13146, Commonwealth v. Nicholas G. Santana.
Okay, Attorney Halpern.
Chief Justice Barrett and Associates Justices of the Supreme Judicial Court. May it please the court, I would like to begin with the statute, the 279, section 27. This statute permits a Superior Court judge who is sentencing a defendant to state prison to order that sentence to be served forthwith. This statute was enacted in 1881, and at that time, there was no such a thing as a split sentence, which is at the core of this case. There was no probation, so every sentence was a commuted sentence. The question is whether the probation that follows the commuted part of the sentence should also be considered to be served forthwith. The Commonwealth points to the words of the statute that say that if a convict serving a sentence of imprisonment in jail or house of correction is convicted of a felony, the court may impose the sentence, the state sentence, to be served immediately, which has the effect of wiping out the house of correction sentence.
Well, we know that's true. Over here, I'm sorry. It's hard to find us. Yeah, sure, it wipes out the committed portion of the sentence. That seems clear. But when you talk about what happens, it's the forthwith sentence being served in the jail or the house of correction. That doesn't seem to address a probation. Even if, I'll say the words probationary sentence. Assume for the sake of my question that probation is a sentence, which I know you agree with. Why does that language, the actual text, reach probationary sentences?
So first, looking at the words of the statute says that after the state sentence is served, the convict shall be removed to the reception center established based on some statute, and shall be discharged at the expiration of his sentence, which is the state sentence. And this statute was amended one time in 1955. At that time, there was probation, there was split sentences. And this part of this section, section 27, was left the way it was. The only change was that before it read, instead of reading reception center, was state prison. So, also at the same time in 1955, section 28, which was also forthwith sentence, that part that I just read, that the convict should be discharged, was amended and actually deleted. In one of the cases, the only case actually that cites section 27 is Dale versus Commonwealth, which dealt with section 28, and the court actually focused on that language, and that the legislature left that language in. But this court has also decided Hennessy versus Superintendent of the Framingham Institution, which dealt with awarding good time, earned good time, statutory good time. And in that case, the court held that a split sentence is a single sentence. It's not two sentences. If the court would accept the Commonwealth's interpretation, this would break up this sentence, the split sentence, into two sentences. And indeed, this part of the sentence, the probation, would follow the state sentence.
But
And
the statute recognizes that, for instance, on your point, there's no more statutory good time, but on earned good time, you don't get earned time for the portion of the split that you're not serving.
Well, that's correct, but the way the court reasoned in Hennessy is really important for that proposition that it is one sentence. So, for example, if somebody has a 2-year sentence altogether, so 1 year to serve, 1 year suspended, that would, and that person then violates probation, the way you have to, according to Hennessy, you calculate the earned good time or whatever good time the person earned would be on a basis of the 2-year sentence, which is usually you get more good time if you have a longer sentence.
I'm sorry, I should have asked this right away. So your argument is that the probationary sentence is wiped out, and so we don't even have to reach some of these other issues. But as far as the Commonwealth points out that you appealed from the revise and revoke, and that there has never been a request to vacate the sentence because of the colloquy or because of a condition of probation, batter's treatment program. And so therefore, you didn't file that within 30 days, so that issue is not before us, and you have to file a motion for new trial under 30B to have those issues addressed.
Well, it's true that didn't happen. So I think the way this court can address the issue that I just raised would be to consider the motion that was filed, the Rule 29 motion, as a Rule 30A motion. I mean, that's actually cannot be really disputed, that the only way to reach this issue is to consider, to deem it to be a Rule 30A motion. Now, the attorney that represented the defendant, she actually said that this is an issue of first impression. And I think it's a really important issue for this court to reach. I would want to say this, that the sentence, the statute, is not a get out of jail free card. It's get out of jail into prison. And prisons were different places than house of correction or jails. They were much more secure. They were basically solitary confinement and hard labor cases. So the idea that this sentence, the split sentence, then should be followed after the state sentence, which is sometimes years, sometimes decades, by probation imposed very long time ago. It acts as a practical matter. It doesn't make a lot of sense.
I'm sorry, can you go to your major issue, though? And I understand we may not reach it, and there's issues about whether it's been raised. But nonetheless, one of the most important points in your brief is that you're saying the colloquy was inadequate.
Yes, the colloquy.
Can you talk about that, please?
Yes. The rule basically is that due process requires that the judge, before the judge sentences some defendant, that the judge is informed about what the defendant actually did. I mean, it doesn't have to be elaborate cross-examination or anything like that, but the judge, before she can actually sentence someone on a violation of probation, should know some facts. And here,
But
They
isn't-
absolutely.
I'm sorry to interrupt, Counsel, but isn't your argument with regard to the batterers program is that the judge punished the defendant for the violation as opposed to the underlying crime?
Oh, yeah, that too. She,
But isn't that, I guess I'm noting a contradiction in what you had said in response to Justice Lowy's question with your argument that the batterers program was outside of what she was entitled to do.
yes, and I actually researched cases from other jurisdictions as well. I didn't actually cite them, but I did. And I actually haven't found a single case where it was clear, like in this case, that the judge was imposing this condition that was clearly not relevant to the underlying offense. And all the cases say that the principle of probation, of sentencing someone, like in this case, it's a straight probation, is for the offense that he was actually convicted for. And I didn't find a single case that the judge could then consider the conduct itself, the violation of some other criminal law, to impose conditions that only relate to this offense that it hasn't even been convicted of. Now,
Counsel, could I press you on that? Because if we zoom out for a minute, and the purpose of the probation is to do what we can to have the probationer successfully complete probation, to impose those things that that person may need to be successful. And if the violation includes, that's been proven by a preponderance of the evidence, that there is some underlying issue with anger, or particularly anger in a domestic situation, why wouldn't it make sense, assuming that the case that generated the probation has nothing to do with that? Let's just say it's an OUI. Why wouldn't it make sense for the judge to say, in order for me to help this person, because they could be sentenced on a violation, right?
Yes.
So why wouldn't it make sense for the judge, within their discretion, to say, here's a universe of things that I need to address right now to make this individual perhaps more successful? Why wouldn't that make sense?
I think that it sort of makes sense, but there are certain and very serious concern about the judge doing that. And the first one is that when the person initially pleads guilty to the crime, like you did plead guilty, and the lawyer cannot tell that person what conditions he's actually agreeing to when he's pleading guilty. This is what's going to happen. I'm concerned about lawyers advising clients to plead guilty when they can't tell them what's going to happen to you. How do you know to even advise somebody that that's good advice?
So you're saying the not knowing about the fact that he could have been ordered to complete the batterers program, not knowing that was the problem?
Well, initially, yes. I mean, this is just one example of how the judge can use the violation of probation to impose additional conditions. And the attorney who represented that defendant initially and advised that he plead guilty.
Yeah, but
How would he know what would happen later on? Do you agree to then go to this program or a myriad of other conditions?
well, no one can predict the future, and that was something that, I mean, he violated the law, right, by assaulting his partner, so.
You can generally tell somebody, like everyone knows, you shouldn't
Violate the
the
law.
law.
That's
And obviously, you're going to be, you can go to prison if you do. But as a condition, that would be something that somebody would have to calculate, do I want to plead guilty? And our system actually works on guilty pleas. So I think that this one or another condition would as well be, you at least should tell somebody as much as you can what is, so they can make a decision whether they want to go to trial or not. And I think that and in addition, this case, the case that he had in another court, and that court, in fact, could impose that condition in any event. So it's not like that condition cannot be imposed even as a condition of release or whatever. So it's not like the government is not protected and cannot use this, the fact that he has a probation and it has been violated on it or committed a crime. It's still, they are means to address the underlying issue in another court, and a court that probably has much more knowledge and facts relating to the case.
Okay.
Go ahead.
No, I was going to say if there's no further questions, but if you've got one, please.
I'm all set. Thank you, Chief.
Okay, thank you very much.
Thank you.
Attorney Blatchford.
May it please the Court, Howard Blatchford, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Chapter 279, Section 27 has 4 predicates before a sentence to a house of correction or jail can be discharged. 1, it requires that the inmate is actually serving. 2, a sentence. 3, of imprisonment. And 4, in a jail or house of correction. Only when those 4 conditions are met would the sentence to a house of correction or jail be discharged. And the case law supports the position that all that is discharged is the sentence being served. There are 3 cases that have dealt with this statute, although largely in dicta. Those are Kinney, Leiden, and Dale, cited in the Commonwealth's brief. And in Kinney, this court said that the court, when sentencing someone, the Superior Court, when sentencing someone to state prison, quote, wipes out the sentence to the house of correction. Said nothing further about suspended sentences or probation. Similarly, in Leiden, which quoted Dale, the 3rd case, which quoted Kinney, the court said the sentence then being served in the jail or house of correction is terminated. Nothing about suspended sentences or probation. The legislature looked at the statutes in 1955, and the only substantive change didn't occur in Section 27. It occurred in Section 28, which dealt with the Concord reformatory and reformatory sentences. But nothing was done with respect to Section 27. The legislature could have added suspended sentences and probation had it chose to do so, but it did not.
So, counsel, as a practical matter, then, the probationary term starts after the state prison sentence? Is that your position?
I believe it would, Your Honor, yes. And the purpose of this statute, I believe, is evident from its text. A forthwith sentence moves the defendant forthwith from the less restrictive environment of a house of correction to the more restrictive environment of the state prison for punishment for a felony, which is considered a more serious offense. And it also avoids the security risk that might attend to an inmate residing or continuing to reside in the house of correction after he's been sentenced to state prison. The Commonwealth's position also furthers the purposes of sentencing and rehabilitation in that construing the statute in a way that would sustain the probationary term and conditions provides for the rehabilitation of the defendant in a way that expunging or discharging that the probation would. Turning to the second major issue concerning the condition of probation requiring the defendant to the batterers program, several points in order. First, the defendant agreed to all of this. Although it's not clear from the record whether or not the batterers program had been discussed with the defendant before he arrived in court that day, it was discussed in his presence, and it occurred before the colloquy with the judge. So it was all out there before he agreed to this and was advised of the rights that he was waiving by the judge. Second, a sentencing judge is not absolutely limited to the circumstances of the crime for which the defendant was initially convicted and punished. The court can consider new information that has arisen since the date of conviction, and this is reflected in the Superior Court guidelines concerning probation conditions.
But those guidelines aren't going to help if we follow Commonwealth versus Goodwin, which requires that the condition relate to the underlying crime. Don't we? So the Superior Court guidelines can't go further or in a different direction than the case law.
Certainly.
So that means that we really need to take a look at Goodwin and see whether or not, as just as George has said, it seems to make sense, I agree, that you can take into account the here and now, what's going on with this person facing a violation of probation hearing. But to do that, don't we have to face up to Commonwealth versus Goodwin?
I think that issue can be addressed in the context of other cases that have been decided fairly recently as well, and that is that the case law on this allows for conditions reasonably related to the goals of probation to be considered when probation is ordered. And I direct the court's attention to Commonwealth versus Feliz, a 2020 case, 486 Mass 510, Commonwealth versus Eldred, 480 Mass 90 at 95, page 218. And the goals of probation have been further defined by this court to include the rehabilitation of the probationer and protection of the public. So I believe that in looking to achieve those goals, the court can consider these additional considerations in terms of what had happened and since the time of his original conviction.
Just so that we have to face what we're dealing with here. We've never reversed Goodwin that requires that you can only impose a condition that could have been imposed with the original sentence.
And I would suggest that this condition was a condition that could have been imposed with the original sentence. It certainly became more apparent after the subsequent crimes that the defendant committed, which brought him to this probation hearing. But certainly, firearms charges in connection with possible domestic violence, they just don't mix well. And this is a matter of common knowledge. It's acknowledged in the literature as well. And I'd point out that the defendant here pled guilty on September 11th, 2004 to the firearms charges in Middlesex. And he was in court, excuse me, I may have that date wrong.
It's
the change of plea was on
2014, but you're saying, okay, sir, you're pleading guilty to possession of a firearm and a loaded firearm. I'm going to impose a condition of batterer's treatment program? You can do that?
I believe so, because I believe that it's well known that possession of firearms, particularly illegally possessing firearms, is a very toxic condition in the area of domestic violence, and I would suggest that this condition was an appropriate condition when imposed.
So, I'm sorry, did the Lowell case, did that involve domestic violence at all?
It did. The original charges, Middlesex charges, were firearms charges, and then the additional charges that he incurred while in the House of Correction dealt with domestic violence, assault and battery on a family member, reckless endangerment of a child, as well as possession of a drug. So clearly the issue was in front of the court when he appeared for the probation hearing.
Talking about the original case for which he was in the House of Corrections. Are you saying that was domestic violence?
No, I don't. The record doesn't reflect that. It was possession of firearms,
Okay.
similar
So
to the.
But I thought in response to Justice Lowy, you said that a condition of probation in that case could have been a batterer's program requirement?
I think that the issue of domestic violence is so severe and so important that if there was any evidence.
Anybody can be ordered to do a batterer's program? I'm confused by your, I mean, I agree with you that it's a problem, but, so now we can just, everybody has to do batterer's program?
If there was any evidence that he was involved with a partner with whom there was any strife at
Right,
all
and
at that
That was my
time.
question. In the record, is there any?
There is no evidence in the record to that effect, no. The first evidence that I believe appears in the record is the notice of probation violation served on the defendant in hand prior to the hearing at which he agreed to all of this, that he had been charged with assault and battery of a family member.
So the issue in this case that probably arises the most every day is the colloquy with a probation violation where there's a stipulation. And you have a preliminary issue as to whether it's appropriate before us, and then you also believe the colloquy is adequate?
Right. I believe that the case law on this issue is that the court looks at the totality of the circumstances at the time of the admission or stipulation to the violation, and whether or not the defendant was sufficiently informed. Here, he received in hand, prior to the probation hearing, the notice of probation violation, which included all of the charges that he had incurred in Lowell during the time, shortly before that, and he was advised by the judge of the rights he was waiving at the hearing. I believe that's sufficient in a totality of circumstances to put the defendant on notice of what it was that he was waiving. It makes his waiver knowing and voluntary.
Counsel, could I press you on that? I understand it's post-dispositional, and I know it's not an apples-to-apples analog. I do. I'm going to give you that. But if he were pleading to an underlying crime, the Commonwealth would say in open court the facts that they would prove at trial should the matter have gone to trial. And the court will ask the defendant to listen to it and ask them if they agree that if the Commonwealth could have proved that they could have been found guilty. There would be some level of expansion of what the underlying facts of the crime are. So by extension, if you're stipulating to a violation of probation to some crime that is not before that court, it may not even be in that court. It might be in some other court somewhere. And all you have is a docket number and the charges. Why isn't it that the judge on the violation needs to have some level of description of what the underlying charge of the violation is in order for the probationer to have some intelligent idea as to what they are stipulating to?
I understand the question, Your Honor. In this case, the defendant had more and the judge had more than just the docket number of the case, the charges that had been brought. The notice of probation violation spelled out what the charges were. Granted, it didn't go into the same level of detail that would typically be heard at a change of plea where the prosecutor would recite the Commonwealth's evidence. But nonetheless, the defendant had notice, he was represented by counsel, she had notice, and notwithstanding all of that, he agreed to do this. So I submit that in the totality of the circumstances, which is the standard that applies in this situation, that standard was met, and the defendant made a knowing and voluntary waiver.
Is it your view that we should reach this issue?
It's my view that you should not reach this issue because there was no appeal from the original June order. In fact, the defendant was completely satisfied with it until he learned that he might have a get-out-of-jail-free card in this forthwith sentence matter. And it was only then that the objection was raised and there was an attempt made to appeal from the June order and the notice of appeal that was ultimately filed the day after the order denying the motion to revise and revoke sentence.
So you think that the appropriate thing to do is to go back and have a new motion for new trial seeking to vacate the agreement, the stipulation?
Well, that's what he should have done, and it wasn't.
But he could still do that.
Could still do that.
He could still do that, right?
Right.
And so what is your response to counsel's argument that we should just treat it as if he had done that?
I would say that he didn't do it, he didn't articulate
Well, that I
his
understand,
reasons.
and I think that counsel has admitted that. But the question was, in terms of the argument now presented at oral argument, that we should just treat it as such. What is your response?
My response would be the correct way to deal with this would be to deal only with the revise and revoke order and allow the defendant, if he feels that the colloquy was deficient or whatever else was deficient with respect to that original hearing, that he should articulate it in a new motion.
Could we address it as a substantial risk of miscarriage of justice?
Whatever he might find
Oh,
it
I
to be.
mean, here.
Yes. So no other questions, the Commonwealth will submit on its brief.
Thank you.